Hi there, it's Michelle Bryant from Property Sisters UK. And today I'm joined by David Kemp, who is a planning consultant from DRK Planning Limited. And we're going to talk to you about the recently announced Airspace PD reforms. Good afternoon, David.
Good afternoon, Michelle. Good afternoon, everyone.
So would you like to tell us a little bit about what you specialise in and how life's been for you over lockdown and about all the recent changes?
Well, I mean, pretty much in a nutshell, what I do is I help people get planning permission where I can, or I advise them whether or not they can get planning permission. We do sort of planning appraisals, we do lawful use certificates, advise them on permitted development, prior approval, all that sort of stuff. And then we also steer some clients through the more complicated aspects of full planning permissions and advise on strategy, costs, and all that sort of stuff as well. Ever since lockdown, it's been really, really busy for us because obviously a lot of developers, they can't really get out on sites all that much. So they're really, really focused on getting ready to get going on their sites as quickly as they can. So it's been quite busy, actually. I'd probably say we've been busier than we've ever been before.
And so these new reforms come in from the 1st of August. And so what does this mean to developers who are looking at doing airspace development via PD? What does this mean and what applies?
Well, I think there's going to be some good opportunities there. Certainly, the reforms that are coming in, how they've been announced, they've been announced with some great fanfare, as Boris normally does, and probably 8/10 of it, we don't really know the detail yet. So there's a number of things around the reuse of vacant shops and redundant shops. So a lot of that detail's got to come through yet. There's going to be a new commercial use class where, for instance, you'll be able to go more easily from one commercial use, say, for instance, from shops to offices or to other commercial uses without necessarily being stuck in the shops use class. Right. And there are some other things around that as well, but we don't know the detail around that. The ones that we do know the detail on are mostly around the new stories permitted development rights to purpose-built blocks of flats. That's the one that's come in so far in detail, and that will take effect on the 1st of August.
Sure. And can you just clearly define a little bit thoroughly for some of our listeners about what purpose-built means and specifically what dates those buildings, what age they are?
Yeah, sure. So with purpose-built, so we're talking about blocks of flats which are not, they didn't become blocks of flats because they were offices first or something else first, and they were converted by planning permission or by PD rights over to residential. So I'm afraid I'm going to have to disappoint you if you've got a fantastic commercial conversion scheme and you're going over to flats and you're thinking, oh, great, I can get another 2 floors on there under PD as well. Your block will not be counted because it's a conversion scheme. It has to have actually been erected as flats. And it has to have been completed as flats and occupied as flats since after the 1st of July 1948. So that's when the modern day planning system first came into effect. And before the 5th of March 2018. It seems a bit of an obscure date, but that's actually the date that the minister first announced the prospect of this PD right to the House of Commons. So it's between the 1st of July 48 and the 5th of March 2018. And if it's a purpose-built block of flats, but it falls outside of that, wasn't completed until after March 2018, then I'm afraid it doesn't qualify. Now, it might also include large purpose-built blocks of flats, which may say they have shops on the ground floor, but
So
they're large flats. Yeah, sort of a mixed-use block, but essentially the block is a block of flats.
Purpose-built flats, right?
Yeah.
So a commercial building would fall outside of the scope completely.
That's right. Yeah.
Okay.
Yeah.
Interesting. And obviously people are potentially getting their applications ready now to submit 1st of August. So there may be an influx of applications and people could be...
Yeah, I think there's very much it's a case of the development community trying to get used to what the conditions are, get a sense for what they should be looking for. And so a lot of my time at the moment on this is spent dealing with clients, looking at the sites as they're coming in and say either it will work or it won't work. I think I've been sent about 5 or 6 sites so far, and I think only one of them works because there's so many conditions or limitations to them. But I think that will change as developers might realize that there are potential gems that they should be looking at, and they're under their nose, but they didn't realize that they fit the criteria. So I think it's people getting used to what they should be looking for. When they get a sense for that, then we'll get probably a higher strike rate.
Got it. Okay, excellent. Right. And just on ownership as well, a lot of people aren't very clear on what airspace ownership means, and when somebody can come along and buy the airspace, or they could sell it to someone else, and just a little bit of a grey area about what having a freehold building versus having airspace means. Are you able to clarify that a little bit for us?
I'll try. I mean, mostly it's a property law question, and I'm not a property law solicitor, although I have a background in law. But generally speaking, and apologies if there are any property law solicitors who are listening in on this, and they say, sorry, David, you're wrong, so I'll bow to their superior knowledge. But essentially, if you have a building and you own the freehold, then you normally have the right to be able to erect onto the top of the building your own structures. But that might be subject to various other permissions. So, for instance, you might have to comply with aviation law, for instance, if you're within a sight line of Gatwick or something like that. So generally speaking, you do have the right to do what you want on top of that building, but limitations might be imposed by other statutory regimes and other regulations, etc. Or, for instance, if there's if part of the rooftop is leased out because it's got telecommunications equipment up there, so you'll be subject to the leases of those telecommunications equipment. But generally speaking, other than that, as far as I understand, you can pretty much do what you like. So if you want to sell on the airspace separately, you can do so. And some people do. They sell on the airspace right separately, so they retain that interest in the future development of the airspace.
Yeah, very interesting. So obviously very important to have a great legal expert on
Yeah, check your... before doing any property development, I always check restrictive covenants and similar kinds of notices on the title, as well as, of course, what you own. So you check what you own, you check your restrictive covenants, notices, and other encumbrances on the title as well. And then, I mean, if you're at ground level, and we're principally talking about development on roofs, but if at ground level, you start also looking at things like contamination, trees, so you can establish what your developable area is, and that sort of stuff as well. So those kind of are the principal preliminary checks you do.
Right. So quite important to have a big checklist before you start.
Yeah. I mean, they pretty much fall into 4 main categories, and they're kind of property law, checking the market and what works and what's not going to work, and trying to see if you can reconcile that with what the planning system is looking for in principle, environmental constraints, and the property law constraints as well.
Just on the permitted airspace development reforms again, let's talk about the conditions and the limitations and things that have got to be met under these rules.
Yeah. Well, there are quite a few conditions and limitations to them. So everybody was getting very excited about the prospect of being able to slap 2 new stories onto their buildings. And then I think the response is quite muted. The conditions probably fall into 2 camps. There are some quite straightforward conditions. So, for instance, if your building falls in a conservation area, or it's a listed building, or for obvious reasons, it's within 3 kilometres of an aerodrome, then, and that just to pick a few, there are a few others as well, then they're quite clear. It's quite black and white. And although I think as developers we accept that there is a need for conditions and limitations to these permitted development rights, we can work with them if they're certain, if there's an element of certainty there. What becomes more difficult is where we get into conditions and limitations which fall into the other camp, where they're a bit less certain. And there are one or two there. Just glancing across at my list on down to my left-hand side. But one of those is to do with external appearance. So the council has the right to consider how you're proposing to extend the building against the external appearance of the building. That's a little bit nebulous. That's a little bit open to subjectivity. There are a couple of other aspects to it as well, and one throws up an uncertainty because of the way it's been drafted. So, for instance, and if you just bear with me, I actually got the statute in front of me. What it says is it has that you have to consider the impact of the amenity of the existing building and neighbouring premises, including, uses the word including, overlooking privacy and loss of light. Now, loss of light can be measured. We usually have sunlight and daylight consultants who can look at that sort of thing as well. Now, depending upon your relationship, your physical relationship to the buildings around you, that might not necessarily be a problem. I mean, you can work around that. You can set buildings in from the sides, and therefore you can limit and mitigate privacy. Not worried about that too much. Impact on privacy of neighbours, again, you can set the buildings in from the side. You can have privacy screens around. That's not necessarily a problem. You might not even be facing habitable room windows. If there are windows to neighbours next door, they might be to a corridor, they might be to a bathroom, kitchen, stairwell, that sort of stuff. The kinds of things you could probably check out by just checking planning applications.
Sure. Okay.
And overlooking as well is a very similar thing, but it uses the word including. So if it includes these things that we have to pay attention to as developers, what is it not saying? What else might it include which is not included in this list? You see where the uncertainty lies here. Now, the government haven't been particularly clear about this, and I expect this is something that might be an area for further debate between applicants and local authorities. As with all new law, there's an element of uncertainty about it.
So further clarification to come.
Further clarification to come, either through specific guidance or the outcome of battles between developers and local authorities.
Because we really only are a few days away from where applicants can be submitted. So applications will be going through and being scrutinised, and I'm sure the submitters will be learning an awful lot more about some of these areas that are not quite so black and white at the moment. So
that's right. Yeah, that's quite a big one. But also worth pointing out that if you fail any of these tests, it doesn't necessarily mean you can't get extra stories on your building. You'd have to go through the full planning application route. So if you're in a conservation area, don't lose hope. You might still be able to get consent for extra stories, but the restrictions will be tighter because you'll have to go through the full planning application route.
And not down the PD route. Yeah, I think that would be quite useful for people to know that. So let's talk a little bit about the no deemed prior approval. That is quite important. So that's time limit.
So many of you and many of your listeners will have already been through some sort of commercial conversion process, or are going through a commercial conversion process, say with offices to resi. And what is commonly known is if you get to the end of 56 days after you've submitted your application and it's been registered and the council hasn't made a decision, then automatically you get prior approval, you get consent for that change of use. And it's called deemed approval. So basically the law slaps a pair of handcuffs on the council and says, you can't make a decision now, we're going to take it out of your hands, you should have made a decision by now, tough, whatever, and now you, the developer, have consent. And it's quite useful for some people, gives them a degree of certainty, and it puts a little bit of pressure on the council to make a decision and not spin things out. Not all of the PD rights have that provision though, and this particular PD right doesn't. So there is a bit of a danger that when your application goes in, the council will take longer than 8 weeks to determine it. And so that can be very difficult to manage, but you just need a good consultancy team, whether it's your architect, the planning consultant, who's on the case with the council. Don't try and rush a decision, though, for the sake of it, because if the council's not ready to make a decision, if you force them to make one, they're more likely to say no rather than yes. So you've got to get them to yes, basically.
Yeah, so you've got to be a little bit patient there. Yes. Okay. Very interesting. If you were, had a crystal ball, what do you see the future looking like with the new PD rights for the airspace? I mean, do you see the London skyline changing, or do you think it's going to be a slow burner?
I think it's going to be a slow burner, not dramatically. I don't think it's going to dramatically change. I think also it depends upon whether or not the economics and the financials make sense to many developers.
Sure.
Because of course, with some of these changes, they're going to have to make structural changes to some of the buildings as well. There may be the opportunity to make use of modular, lightweight technology as well. I think, though, I can see where many local authorities might be quite happy to see greater density development in their towns and centres, more development going up, because it brings people closer to where they shop and where they work. It cuts down the need for the car. It's more sustainable. Mm-hmm. That will put more of a pressure on the need for air filtration systems in buildings, cleaner air, and so on and so forth. But then again, if we're not using the car so much, and then we're working more from public transport hubs, etc., or if we're working well away from town, that's where we're making a choice to do so, because we can work remotely and then go in only occasionally as well. So I think what will be interesting is how the long-term decision-making of people generally changes, out of the lockdown, because people who didn't work from home quite regularly beforehand are now kind of getting used to working from home. They don't necessarily want to go back to work and get on the train and get on tubes and buses again, and probably won't want to do so for quite some time. So I think the property industry needs to adapt to that. Sure. And I think local authorities want to adapt to that as well. But it isn't going to be easy I wouldn't expect there's going to be wholesale changes in terms of town centres where you have a large number of redundant shops to suddenly switch over to residential. I can see councils putting up quite a lot of resistance about that, and losing offices to residential as well. They want to safeguard economic activity in their towns and centres. But I think developers and local authorities need to think creatively about that. I mean, retail has become much more of an experience-led thing, particularly if it's physically rather than buying from Amazon or buying online. Mm-hmm. And I think developers need to think creatively about how they fulfill that experience for the shopper and keep town centres alive and relevant to people.
Yeah, it's certainly going to be interesting, isn't it? So, so thank you very much for all your insights, and I look forward to hearing how things go, and all the best with your applications and work over the next few months, which are certainly going to be interesting times. So,
thank you very much, Michelle. Cheers. Thank you.